Good afternoon, everyone. It's Matt Doran here from the CIArb, and I'm joined by David Yeck, who is our special guest speaker this afternoon. Thank you for joining this afternoon in the UAE. If it's morning, if it's evening, we're very grateful for you to be joining us today. David was introduced to us at CIArb through the Abu Dhabi Hub Committee. A gentleman called Sabah Qureshi, who's one of our members and our committee members. So we'd like to say thank you very much to Sabah for introductions and bringing David to us. He's got a very good reputation in terms of his background. He's going to give us an architect's perspective on contracts today, which is going to be extremely worthwhile. So we'll give it a couple of minutes and then we'll get started. So I'm just seeing who's in the audience. If I can give anybody a shout out, let me just have a little look. There's one or two people that come regularly to the webinars, David, who are always committed to the CPD events. I see Biplab there. He's forever attending our events. Thank you very much for your ongoing support, Biplab. I can see Edmund as well. Let me see who else. If you could, if you're in the, if you're just waiting for us to start at the moment, on the chat here, it would be great if you could just tell us where you are in the world. We always get excited because we know we've got roughly 20 countries across the world registered for today, but we'd love to see where you are in the world. So pop a little note on the chat, tell us where you are, and perhaps tell us whether it's sunny, rainy or snowy. That's always interesting. I can see Sarah from our Dubai Hub Committee. Thanks for joining, Sarah. Just looking for others. Yeah, it's growing lists. So I'll turn my attention to the chat. Who have we got in the chat now? Oh, Zaga. Yeah, Zaga's a regular as well from Saudi Arabia. So we've got Malaysia, obviously, David, so your home country. So congratulations. We've got people in from Malaysia, people in from Kuwait. I'm Murtaza. Zaga's in Saudi. We've got people from Qatar. We've got a big following in Hong Kong today as well. So thank you very much for tuning in from Hong Kong. China, excellent. Yeah, so pretty good representation. And of course, did you see somebody else, David? Did you see somebody?
You have mentioned all the names from China, Hong Kong. Yeah, and I think Dr. Zoe is in from Malaysia. Ah, excellent. Yes. So you will have a few people that are close to you, I'm sure, following you on this event, but we will have quite a lot of people who are tuning into you for the very first time. So thank you very much for following us. And yeah, we'll get started in a few minutes. I've got, I'm in the Dubai office currently for CIArb, and Lauren is also here behind the scenes, and she's going to be working the chat. So if you can please keep an eye on that. We do have some useful links all about CIArb and what we're doing and what we stand for going into the chat box. So keep an eye on that. If you have a question for David, please put it in the Q&A box, because the chat, although it's very good, it goes very quickly, so we might miss your question. So please put it on the Q&A chat, the Q&A tab, and then we can refer back to your question towards the end. Okay, so great. We've got a firm 50 in the audience today. So good start for this lunchtime or this evening. But I'll take no longer, but to hand over to you now, David. And everyone sit back and enjoy. Thank you, David. All right, thank you, Matt. Well, let me go through my presentation today. So it's going to be, initially it's going to be quite long, but then I only have 1 hour, so I try to trim it down. So let's begin with this. Now for all my, for all my presentation, I will always have this in the beginning as a caveat, that this webinar is purpose for the education purpose and not for any legal advice. And should you need a legal advice as to the case that you may have, I will advise you to get a lawyer.
And you are strictly reminded that any opinion stated herewith are the presenter's own opinion, which is mine, and shall not in any way whatsoever taken as a legal advice. And in the event any scenario presented which may reflect actual scenario you may have experienced, this is entirely coincidental and has nothing to do with anyone dead or alive. So I hope that this will clarify a lot of things. Okay, let's go. Basically, the scope that I'm talking about today is broken down into these three parts. Part one, which is the overview of the construction law, it stands as your roadmap. And part two, which is the various international contract, which is basically your vehicle. And part three, the journey, which is going to be sometimes a roller coaster. And of course, this is where the dynamics is all about. Part one, let's go with the roadmap. Now, basically, when we say, what is this roadmap? We always refer to the first thing that is at hand, which is the construction law. And what is this construction law? And is this a statute to begin with? And if not, what constitutes this construction law? So I will look at this construction law is just like a salad bowl comprising of various laws, notably the law of obligation, which in this aspect covers contract and also extra obligation that we call it tort. And you have the reference of this construction law from various authoritative textbooks, such as one by John Oak, which is a very nice written work. It's concise and it's very easy reading. Of course, you have the big guys, like the Hudson's Buildings and Engineering Contracts, the key things, and of course, the new one that is being minted, the 3 volumes by Julian Bailey. You can get this in the market. So all this is a good reference book for construction law. And what is this construction law? I would like to just make it into a nutshell perspective that number one, it actually outlines the obligations. It always starts from obligation where it tells you the obligations of the employer, the contractor, and also the consultant. So these 3 main parties in the construction law will tell you what these people are supposed to be doing, how are things are to be executed, and who is going to say this is correct or that is wrong, who is going to administer it. So this is the perspective coming from myself as an architect. I will base on this obligation to tell my side of the story. Of course, when it comes to construction, there's always the beginning, which is the starting point, and of course the end point, which is the completion of the project. Now, whatever happens next after the post-completion, where the defects are and so on and so forth, that will be something to deal with in the later part. But I'm going to look at just between the starting point and the ending point of the construction, where the dynamics happen. So this is where a lot of issues that's going to happen, the delay event, variation, instruction that is going to take place. So this is where our journey actually begins, okay? And this is also where we see ourselves as contract administrator to intervene, well, sometimes to mitigate even between the obligations of the employer as well as the contractor. Okay, in the contract law, as far as the textbook is concerned, it's always been classified as the main body of the contract, which is the construction of the contract, where you have this legal representative relationship, offer acceptance, and so on and so forth. Then you have this term of the contracts, and in within this term, you have the variation termination clause and also the rest of it. But I would like to make it even more simplified. If you look at the contract, there must be this important aspect that has been covered. Well, I actually coin it as the 3P, which stands for parties, who are the people involved in that particular contract, and what is their local standard, and the property, where's the work, where's the location, and of course, the price. Therefore, the 3P stands for the parties, the property, as well as the price. So this is what has to be reflected in the contract. Then we have the 4T, which represent the terms, which is the conditions, the warranties, and all the other innominate terms. Then you have the time. It has to have a starting point and the ending point, the duration of the work. Then, of course, there is timing, where certain obligations require procedural notice. Yeah, failing to comply this procedural notice will get you into what we call the time bar. You are not allowed to do certain thing, or you have forfeited your own rights to do certain thing. So timing is very important. And of course, the last is the termination clause, where if everything fails, this is where it's going to save you. So it's the last resort. Then we have this DEF square, which stands for dispute clauses, if there is one, or is it in the form of multi-tier. And also there's these exclusion clauses. For example, you have the provision for insurance to cover your liabilities, force majeure clauses for your EOT, and so on and so forth. Or for the matter, if in the international context, you have the foreign law clauses, which involve the private international law, and so on and so forth. And the biggest concern that we wouldn't want to see in any contract is to happen with all the damages and so on and so forth. So what kind of damages we're looking at? So this is 3D, the normal damages, which is following the ruling of Haley and Baxendale. The damages which is consequential in nature, which follow the Victoria Laundry. And of course, the penalty damages, which currently follow the Cavendish Square, whereby is to say that you don't even have to prove your losses or your damages. It's deemed to be taken as it is. So these are the things that is covered under the law of contract. Of course, there is extra contractual liabilities that covers tort, especially on the duty of care. And as architect agent to the employer, there is something called the professional negligence. So this is something that we have to look into it. There's something extra from the provision of the contract. Of course, the elements of construction and the law will comes into play. There is the dispute resolutions, and the party involved, of course, the law obligation, and so on and so forth. So we have covered that just now. Now, as a contract administrator, you ought to build up a corpus of knowledge of the law with its relevant authorities, be it case law, statute, or other reliable legal commentaries. Now, these are basically the arsenals for contract administrator, okay? Especially when you ought to weigh some arguments of the party and not the other. And of course, in the process of weighing the claims based on what the law holds, you can't just pick up some principle from thin air and say that you are right and everybody else is wrong. So up to this stage, you are concerned as to what sort of standard from the parties that is employed. And the construction law itself is the body of knowledge. And the standard form tends to shift the risk from one party to another. So we have a standard form that is the way it is being structured, as the way it is being prescribed. It actually moves the risk around. Some of the risks from the contractors are parked against the employer, but most of the time you'll find that the employer's risks are being parked to the contractor. And this is what standard forms are normally being designed. But there's always a good point to say that the standard form is so often used and so often changed and amended. Somehow the risk is distributed evenly between the party. But then we still see sometimes standard form has these novelty clauses that being put in, but it's yet to be tested in court. So this will set new precedent. And comparatively to the countries in the Middle East, we have this idea of good faith. I think in the Middle East, the Sharia law requires the principle of good faith to be the overarching principle in law. But I don't think the principle of good faith actually applies extensively in the Commonwealth country that uses the British common law rules. Well, we will see how it goes about. Okay, then for example, in the lump sum contract, we're supposed to be said it's a lump sum, but then if there is a variation, it's still no longer a lump sum, it's still subject to a final measurement and so on and so forth. So these are well established method that is agreed by the parties here. Now let's go to the idea of procurement first, because the whole idea of this vehicle is actually to govern procurement. So it's basically a process of finding and agreeing to terms and in the acquisition of goods, services, or works from an external source, often via a tendering or competitive bidding process. So we have these generic types which covers traditional package deal, management contracting, and of course the new kids on the block, which is the partnerships. And the art of advising which procurement routes are best suited for which project scenario based on the commercial undertaking. So sometimes as contract advisors or even administrators, we are asked this question, which kind of standard form that we should apply? So the answer is that we have to look at this entire scenario. Look at it, the metric evaluation methodology. So we will look at the context of the project we are undertaking, and we value it in the metrics way to see which is the most suitable. Of course, there is also the multi-tier tendering. We have 2 or 3 tier tendering to actually narrow down the options of who are the tenderers. Then we will also use the form that is most appropriate to a certain undertaking that we undertake. So the common procurement route we are looking at here is basically the traditional, which is the package deal, the management contracting, partnership, and of course the lawyer loves this, the bespoke contract, where you can actually tailor suit to make, to take it happen with your special kind of project. In Malaysia, the Putrajaya, for example, is under this bespoke contract. Now, traditional, everybody knows is there's another term called traditional general contracting, whereby there are 3 parties involved: the employer, the contractor, as well as the core consultant, which comprises of the employer's agent, namely the architect, the engineer, and so on and so forth. So this consultant, basically, like us, we are the agent to the employer, and also we have to act as an impartial certifier to the contractor. So equally important in this arrangement of the traditional contracting, there is a separate component between design and also construction. So this is where the consultant will have to prepare drawings. Everything has to be cooked before it can be called for tender, where the contractor is going to come in to put a price on that drawings. So you have to wait for the drawings to be completed before you can do the other. And while saying this, the contractor undertaking the job can actually go out and subcontract their work by bringing in their subcontractors. Of course, we are looking at here, sometimes the employer may say that I want you to get subcontractor from the list that I have. So it becomes the nominated subcontractor in these instances. Then the advantage is being that because the drawings are fully developed and undergoing some competitive pricing, tendering process, and so on and so forth. So the pricing is deemed to be competitive in that sense. And there is something called the, what we call the, you can achieve what you call the milestone target. That means to say when the contractor reaches a certain milestone, then he will be paid based on the milestone. So it's going to be an interim payment. You don't have to pay all at one time. And these are basically the advantages. Of course, the contractor is indemnifying the employers once he taken the site possession. But the drawbacks, of course, you need the drawing to be well cooked before you can go for tendering. So this is a little bit time consuming in that sense. You know, sometimes standing in the point of the architects, there is no perfect architect in this world, so you don't expect there is a perfect drawing to begin with. So there is a lot of things that the architect could design, but it's not necessarily mean that it can be easily constructed. You know, there's 101 things that can go wrong, even with the perfect drawings that you have. This is because of the method of construction and the level of technologies that is being employed. Take, for example, we all understand that contractors are basically good in constructing. So in the traditional way of arrangement, you can't call in the contractor to give input. You were basically working in silo and get your drawings done before you call to tender. And that's when the contractor comes in and tells you there's 101 things that goes wrong with your design. So it's going to go back and forth, and it's going to be extremely time consuming, and it will end up with plenty of variation and so on and so forth. So this is basically some of the drawbacks which has been complained on this traditional contracting. But the good thing is that because everything has been tested out, so there is a lot of legal precedence governing this traditional procurement method or this particular system. And like I say, the traditional contracting is time-tested, is dependable. Employers knows what risk they are facing. Even consultants carries single point responsibilities. There is a lot of case law that they can refer to, and there is extremely competitive selection of consultants and contractors too. So there is price certainty. Variations is relatively easy to manage, and well, the best thing is a lot of subcontracting. Of course, the disadvantages that I told you much earlier is outdated. You have to wait for the sequential design to be completed before you can call in the contractor. And there is always a risk of mismanagement, especially if the design, or not the design, if the contract administrator is not well experienced. So, having said that, there came this package deal, which sometimes we call this the umbrella label. Turnkey design and build, construct, contract, and of course, this engineering, procurement, and construction. Now, it's available in standard forms, and its characteristics of this package are this design manufacturing, called fabrication management, or we call this a concoction contract. There are also the contractor may be obliged to financing. You know, you have in Malaysia, particularly where the contractor which is coming from China, they can go to as far as the extent to actually finance that project. They come and say they don't even need you to finance or pay their interim payment. They say, we will finance everything until practical completion or substantial completion in that case. So the beauty of this is there's really a single point responsibility, which is the contractor. Of course, there are other variants to this. There are turnkey, turn on the key, which build, operate, transfer. And also there are other government-linked projects under the Private Finance Initiative, the PFI, which undertake perhaps the fast-tracking design and construction. There are also package deals, which are simpler. Employer obliged to just provide the comprehensive brief, and they will just accept the preferred design package. So, and their main obligation is to make payment. And the contractor covers the rest of the thing, including design, construction, or maybe even finances. And they will employ their own core consultants. So the core consultants appointed are basically possibility to be novated from the employer to the contractor. And they are also responsible for the contractor on that sense. Of course, there is this idea of novation whereby it's a contractual obligation which can be transferred to another and usually carried out by a tripartite contract, which extinguish an existing contract while replacing it with a new one. But the limitation of this is there are certain contracts that prohibit novation, although it's quite rare. And there's a constant, the constant implication that you need to carefully understand what are being drafted in the novation contract. Okay, where is novation is going to take place, the form of the agreement, the time scale, and also the party's identity. Of course, the English law provided the novation involves only contractual benefits and burdens. Package deals advantage are basically a contractor's single point responsibility, and the idea of fit for purpose comes in, although it is sometimes good on paper, but difficult to pinpoint. Fast tracking, as I say, the design not necessary to be fully cooked. And of course, there is also some price certainty. All right, so these are some of the advantages of package deal. Of course, there are disadvantages that once the employer has accepted the offer, he can't just simply come in with his new set of amendment. So once there is amendment, then the package deal is basically broken. And there's not much choice to compare apple to apple, because you either accept that design that is proposed by the contractor or you just leave it as it is. So this is the issue with, or the disadvantage with this package deal. Then there's these other forms of procurement. You have this management contracting, whereby there's this project manager that manages everything. Of course, the advantage again is privately funded, advantage of design and so on, but the disadvantage is usually being exploited for maybe political reasons. And the new kids on the block, this is what I always say is the partnership and the collaborative contract, whereby this is very interesting in the sense that we don't look at it in the adversarial environment. It is more like collaborative. That means that if there is a cost saving, it will be shared between the employer as well as the contractor. And if there is any issue, it has to be resolved by both of them. So this is something that I think every construction industry should go forward to. It's a new direction in practice. Of course, there's other variants of this partnership that you can read from here. And the form is coming out with the partnership charter, the standard form of contract that is being used, and also the partnering agreement. Well, there's an advantage, like I said just now, that you can have a key performance index that measures everybody's performance. Of course, the drawbacks is there is very little legal bite at this moment. And these are the bespoke contract that I've said, where the lawyers will come in and try to tailor suit your needs to these contractual terms. And of course, when we try to select a procurement route in a scientific manner, we can always break it down to first identifying the object or the constraints, then comes to the selection criteria and the weighting criteria, and then you chart the appropriateness of all these forms against your object, and then you review it. Then only you come to your preference and also recommendation. You can do this scientifically with this table here, and you classify it or you give a ranking to it, and then you do your review and selection. All right, so we come to the part 2, which is the vehicle. We are looking at the contract per se now, which is either FIDIC, JCT, or the NEC. Now we start with the JCT. Basically, JCT is domestic UK favorites until today. Malaysia, we adopted the JCT, but in a different form. We call it a PAM form. And the FIDIC form is basically used in international contracts with international infrastructure contracts, dam, roads, highways, and so on and so forth. In Malaysia, we've seen that this is being modified to be applied into the what we call the electrical pylons construction and so on, you know. Then we have this new one, which is the NEC. They were saying that this is so successful in Hong Kong, and it has been also been used in the Middle East as well. So we are also looking at these NEC forms as well. Now, starting with the JCT, used to be, everybody has a start with a humble beginning, but JCT has since grown with these few different varieties. The building with quantities and without quantities, there is the core. The rest is, we have the intermediate, the minor works, the short form of the subcontract, and also the design and build contract. So these are the varieties of JCT that you can get in the market. So the best thing is in JCT is still used widely in UK, because I believe that this is so good that they don't decide to export it out. So it's just like in Malaysia, the PAM form has been used extensively. The idea is because they know what is this devil, even though they know the problem with JCT, which is used to call it, it has this farrago of obscurities in its legal draftsmanship. Remember, there was a time where you see the contract, it has this term called to the satisfaction of the architect. Notwithstanding the fact that FIDIC also has this clause saying to the satisfaction of the engineer. So it comes a time when you ask this question, how do I satisfy the architect or the engineer? You see, the issue with English language is that you can satisfy somebody in many other ways. So there must be a certain context when you read this meaning of satisfaction. So before we go further, you have to understand the philosophy behind the JCT is basically telling you that everything comes from the ideation of the architects, where he puts his idea into paper. It could be just a drawing. So the next thing is to actually translate that drawing into a built form. So this is where the role of the architect has changed from being a designer into a contract administrator. So to satisfy the architect as the contract administrator is basically just to make sure that whatever be translated from drawing into build form is exactly what the design intended it to be in the first place. So it's just that all. But things are a little bit complicated when projects are a little bit more complex, whereby the architect is no longer a person, but a firm, a group of people with different backgrounds and different design intent. So that is where the problems comes in. So that's where when the legal draftsmanship comes into being, he wants to actually put things into perspective. That's where the legal things comes into it. So when you say to the satisfaction of the architect, it means to say he has to follow what is agreed by the parties in accordance to the contract. So things changes, and of course there are new varieties that comes about it, like design and build, and so on and so forth. So that's where you have all these different forms, even within the JCT families. Then you have this FedEx contract, which is used extensively in infrastructure works and also overseas project. It's coming from the engineering perspective. So you can see it's identifiable from the colors. And yeah, it is more straightforward in that sense. Of course, the FedEx, you have this FedEx suites with different colors. The red book is basically the engineering and the construction traditional contract. The yellow book is more of a design book. Silver book is the EPC turnkey project. The gold book is the design, build, operate. The pink book, which the MDB harmonized edition. Development banks, okay, they uses this pink book. The green book, which is the short form of contract, and of course the orange book, which is the design and build and turnkey. Okay. Then we have this new variety called the NEC. Previously it was NEC 3, now goes to the NEC 4. All right, let's begin some of the journey. Now, giving instruction is very interesting in the forms of FedEx. You see, it's quite different from the JCT, whereby the architects can just, they are free to actually give instruction. They don't have to go back and ask the employer for consent. But in FedEx, the question is, must the engineer ask permission from the employer? And the answer is, for certain things, yes. You have to go back to the employer and ask for permission before you can issue our instruction. And the other question, of course, where are the impartiality of the engineer? You can't even give an instruction. Where is your impartiality? Especially so, when come dispute, the engineer will have to determine first. You see, so in FedEx, the other good thing is you can see here is actually employ what we call the expert determination. All right, they don't call it expert because they deem the engineer to be the expert. So in this particular case, the expert determination actually has been factored in as the first thing you go to if you have a dispute. And the question will always come back, if the engineer will need to go to the employer to get consent, how impartiality can the engineer be? Right. But then we all have to understand that the contractor must accept the fact that the engineer needs employer consent. That's how the FedEx is being drafted in that way before issuing EI. All right. Yeah. So this is also consistently correct, because beside issuing certificate where the engineers or the contract administrator in this case has to act impartially, other than that, he is basically an agent to the employer. All right. Then, of course, the other question that may come in if let's just say the contractor simply refused to abide to the EI and say that this EI is absolutely unreasonable. What is going to happen next? Well, in these circumstances, some jurisdiction says that the consultant has no fiduciary duty to the contractor. For example, in Malaysia, in one case, I think it's L3 architects cases, where the finding is that the consultant architect has no obligation to the contractor. So basically to say that he can actually issue wrongful certification, and then the contractor can't go against him in the court of law. So this is some limitation that we are facing at this moment. Okay, so what if the engineer refused to issue EI and the employer decided to terminate him for convenience? So the shortcut both ways. One is that the contractor does not want to follow the EI. The other one is in the event that the engineers finds that the request from the employer is so not logical and you just refuse to issue an EI, what can be done? And he get himself terminated by the employer. Can it be done under FIDIC? Well, the earlier version of the FIDIC, this can be done, but since then FIDIC has changed its clauses, and now you need to get the contractor's consent before you can terminate the engineer in this matter. So next, what can the contractor do to avoid complying to the EI? Well, he can go back to the engineer and say that, sorry, your EI is not going to sound perfect and so on and so forth. So can you think it over? And if the engineer thinks that, yeah, maybe there is a reason for the contractor to raise this up, he may change, he may just withdraw his EI. Then of course, the other biggest issue is actually in this variation. Now, in the situation or what grounds that the contractor may not want to follow a certain EI is because the contractor refused that this variation happens, especially when the contractor is in the situation where he did not get his payment timely. So number one, he didn't get his payment timely and you ask him to do variation work. Okay. So under the DNB, can the engineer issue variation to the employee's requirement? We know that under the design and build, you can't have actually variation to the design. This is a design that you agree, then you have to live with it. But the fact is, can the engineer actually issue variation based on the employee's requirement in the design and build contract? Then the second question is, what happens if the employee itself has got financial issues? Right? Just now I've said, you don't get paid timely, and yet now you're asked to do variation work. It doesn't gel up everything, you see. Now, even worse, what happens if the employer asks the contractor to do something which is illegal? Take, for example, if it happens that during construction, they found a pot of gold, or there's a Mayan civilization buried under the site. And the employer said, just complete your project. Don't bother about it, you know. There's something illegal about that. So what are you going to do? Are you going to just follow the instruction blindly? Now, what if these variations actually incur the loss of profit? Okay, the loss of profit on part of the contractor. Now, instead of spending, let's just say 5 years doing your work, now he has to spend another 10 years. He may have to forego certain projects that he ought to undertake somewhere else. Can this be mitigated by the FIDIC forms? Now, what if a variation occurs when the information provided by the employee is wrong? Yeah, now this happens a lot, okay? Some of the information, for example, especially ground condition, there is this component whereby the contractor undertakes the substructure work, and the information provided by the employer is absolutely incorrect, and they have priced wrongly, and now they have to suffer the consequences of taking that job with that price. What is going to happen? So all these things has been addressed by FIDIC in one way or another. Okay. Then we come to this wrong employer's data. Well, the engineer may insist the contractor to absorb costs, citing that it fails to verify prior to acceptance. Just like the situation whereby the soil condition is of concern, the engineer may say that you have taken due diligence, you have inspected the site. Well, you can't come back to me and say that I give you the wrong information. You must, in the first place, verify it. So the other issues is, can the contractor avoid and on what ground? In actual fact, yes, the contractor can actually avoid, but under a very narrow situation. Let's just say that the error is, let's just say, less than 3%. Then if it's less than 3%, the contractor will have to absorb it. Because with our modern technology and so on and so forth, the error of 3% is understandable. Yeah, but if it's more than 3%, let's just say I want to build a highway from point A to point B. Instead of that, I ask you now to build a highway from point A to point B and to point C and to point D. So it's a totally more than 3%. Or rather, the information is so substantially incorrect, then there is a remedy that the contractor could actually gain from the FIDIC clauses. So like, for example, here the wrong data only constitute 2.9% of the work. So it is 2.9%, which is less than 3%, yeah? So it's deemed to be absorbed by the contractor. Now, what if in addition involves highly technical work beyond the competency of the contractor? Now you go back to the question that we visited last time. You dig a hole and finally you find there's a Mayan civilization buried under. It's totally beyond the competency of a normal contractor. You need Indiana Jones to come and salvage the situation. What would you do, you know? So that kind of issue that you can raise by looking at this FIDIC contract. So if everything failed, there is an ability to discharge. Now look at the contract discharge. Termination, which way to terminate. Damages, if there is any, or there is any limits that are actually provided by the FIDIC contract. If I'm not mistaken, FIDIC contract cap the limit of these damages. And what are the dispute resolution that is provided? So this is always the what next question, you know? And the issue of is this dispute resolution actually final, or there is other way to go about it? So what is final? Is it really final? And again, when the dispute resolution comes into it, is always the question of the English law versus the world. How is it the FIDIC has provided for? If I'm not mistaken, the earlier version of FIDIC applied the substantive law to be English law, but now knowing the FIDIC has been used worldwide, so it opens up this the choice of law to the party in disputes. Of course, when it comes to choice of law, there is always this inbuilt mechanism to actually follow the ICC rules. But due to the changes in the ICC rules itself, whereby only the ICC could actually adopt the rules, now this is something that the party has to change or has to modify from the contract. So the dispute resolution, if you look at the FIDIC, is it a multi-tier? So which one comes first? So if you look at FIDIC again, it will be the adjudication before the dispute board, and there may be an amicable settlement. And lastly, of course, the arbitration. So there is a default hierarchy of the order of priority. If there is any error in the drawings and in the letters and in the documents. So this is how it's being laid out in the FIDIC. Then we look at the NEC form, which is formerly was the new engineering contract. It's an interlocking family of contracts published by the Civil Engineers, ICE. Now, story time. I understand this NEC from a time when I visited Hong Kong back in 2018, when I attended a course in the Hong Kong Statutory of Payment Legislative, or we call it the Hong Kong Adjudication. Okay, so during the course, the NEC was greatly promoted, and given a fairy tale story how good it is. You see, I come from a background of adversarial. That means to say the contract that I'm familiar with is always the contract administrator always do nothing, just sitting down there and hope things happen and try to mitigate in between. Now, after so many years, more than 20 years administrating contract, let me tell you, we don't actually follow strictly to the provision of the contract, because we know that if we follow strictly the provision of the contract, nothing moves. What we adopt is always the consensus approach, whereby if there is an issue, we always call the employer and the contractor together raise the matter up and try to find a solution. Likely or not, this is the amicable way that actually make projects completed within times and within budget. Most of the time, there's a lot of project that's been completed, not necessarily going into dispute arena. And the beauty of this is all this methodology is actually adopted in the NEC approach. I just learned that back in 2018. So there's something that I cannot believe. Now, there's one friend of mine that actually brought one of the trainer back to Malaysia and tried to introduce it to our Malaysian version of CIOB, you know, and also the Malaysian version of what we call the Developers Association. We tried to sell this idea. Unfortunately, the whole idea was ceremonially given the boot. It just simply cannot accept this new idea. You know, they still prefer the what we call the arm twisting technique of the adversarial method of contract. So now the only thing that I can ask myself is why this thing happened. Okay, so dealing with the NEC requires a total mind shift. And it's a different mindset, totally and absolutely. You cannot bring the understanding of the JCT or FIDIC, then look at the NEC. It cannot work that way. So it's very good that we now try to understand this angel. We are so used to the devil. Now we look at this angel and perhaps we can fall in love with it. So now the NEC. The NEC is being structured in such a way that there are core clauses, there are main options. There are also the ADR options. Of course, there is a secondary option. There are schedules of course, and also the contract data. This is how it's being structured, very organized. So the core clauses are all the, what we call the conditions of the contract that you find like in the FIDICs or the JCTs, all there, all right? Then there is something called the compensation event. The meaning of compensation event, you need to say if there's anything that is totally going to derail the whole project, okay? That is something that to be raised to everybody's knowledge. So this compensation event is meant to cater for that. So always there is a niche, there's a requirement for the notice to be issued. So the issue of the notice of compensation event, the quotation is being given, and whether to accept or not is another question. But when all these things done, move on. Don't stay with the problems, just move on with it and complete the project. That is the idea, the overarching idea of NEC. So there is an inbuilt of the early warning. If there seems to be something that is going to, what we call derail the whole project, the contractor has to issue this early warning. And once the notice has been issued, we will have to look at the issue and study how to repair those defects. Look at the issue and see whether is it categorized as the compensating event or not. All right. So there are other things that is not allowed for example, the repair of the defects, unjustified site reports, and so on and so forth. These are due to the negligence of the contractor. Of course, it cannot be considered. So the main option, of course, A, you have this lump sum with all these things listed down there. Option B is actually the price contract with BQ. Option C is the target contract with an activity schedule attached. And option D is the target with the BQ. And option E is the cost reimbursable. So you can see there's a various options to cater for various needs of your procurement technique. And of course, the NEC 4 comes with a new addition, option 4, which is the management contract. Then the option G is the consultant's cost. Meaning to say the consultants who offer themselves to work overseas can actually employ the NEC form as well. Then the other ADR options, which is the W1 and W2. W1 is a standard option for all the ECC contract. W2 is applicable for UK because of the HGCRA or equivalent to the Malaysian CIPA. Then the NEC 4 has got this version, what you call the option W3, which allow for adjudication, which allow for DAB for international ADR. DAB stands for Dispute Avoidance Board, which means to say you must actually do mediation before you take any other options. Then you have got this 19 clause, which is the X clauses, where you can put in all other things like the inflation, the change in the law, the currency, and so on and so forth, which also involve BIM, transfer of rights, and so on. So there's a lot of flexibility actually inbuilt within the NEC forms of contract. And of course, the option Y, which is based on country specific. And option Z allows people to actually change the condition of the contracts. Okay. So there are the schedule of cost component. There are longer schedule and so shorter. There are the contract data. One is to be provided by the employer. The one is the contractor, and so on and so forth. So there are a lot of inbuilt flexibility in this NEC contract, where you can look. There's a list of it here. Okay, so it's actually based on a proactive model whereby the overarching principle or spirit of mutual trust and cooperation. So if you have the idea that I must win everything, or you know, I must take everything, and you are always the losing party, you cannot undertake this under the NEC, because the fundamental principle is actually on the spirit of mutual trust and cooperation. Okay, where parties make mutual commitment to the charter and complies to all the contract procedures, even involving co-location of different actors within the same office. So you don't have a situation whereby you have the employer's cabin, you have the contractor's cabin. You know, one can't go to another. You know, there's secret things that must be hidden away. No, there's no such thing. Everybody works under the same roof. So the opportunity is the goals that set up from the start for mutual respects. So this is the commitment when you want to use the NEC form. And also there is a seamless communication between the parties, all right? They share the same drawing, they share the same information, and all this undertaking the principle of good faith. So if this apply in the Middle East, where the good faith principle is the overarching principle, the legal principle of the Sharia law, then this NEC form is one of the better choice to do. In fact, I was told in Hong Kong, it is so popular that most of their big projects is actually using these NEC forms of contract. Okay, so you can read here is basically under the mutual trust and cooperation spirit. Everybody have these core objectives, all right? Starting from the employer takes the project manager and supervisor to manage the entire project. So the administrator now takes a different name, it's called project manager, no longer the architect or the engineer. So where is the architect and the engineer? In this case, the architect and engineer is given a different role. They are called the supervisor. Their role is basically to control in terms of the quality of the product, the standard that is being applied. They are no longer being bogged down by the issue how many extension of time should be given to the contractor. He's no longer being bogged down to the days-to-days management or administrative of the contract. So you can see the architect, the engineer has got a more flexible, bigger room to actually concentrate onto their core work, which is design and implementation of what they have designed. All right. So the project manager is just to manage the contract administration, while the supervisor, which is the architect, the technical people, now taking a different roles altogether. And the contractor is providing the works. There is also another party called the adjudicator, which is will be called upon if there is a dispute. Okay, so you don't have to wait until a dispute arises. There is always the adjudicator that you could call upon when there's an issue that needs to be resolved immediately under the same roof. Yeah. So in the event of there's a potential delay, okay, there is a difficulty impacting costs, and there may be also time issue, which is unforeseen. Take for example the COVID, the issue with COVID. These are all unforeseen. Of course, they don't call it force majeure. The contractor have to give the early warning and apply foresight. That means we see that these are the things that's coming that is going to derail their project, they have to give a notice. But if they fail to do it, then they will be sanctioned. So the mitigation involved will be the risk reduction meeting. Immediately, the project manager will call for a meeting to resolve all this at one time. Okay? Then he will issue the subsequent instruction as what to do next. Okay, there will also be a risk register that actually record down what are to be revised and what are to be removed in the risk reduction meeting, and what is the cost that is also involved. So this compensation event is actually a mechanism allowing contractor to actually carry on non-financial risk as a result of there's any change or to avoid any delay and also cost overruns. Where is to be identified and what are the procedures that has to be put in place, okay? So theoretically, this compensation event covers 19 events such as obstruction to site access, instruction stop work, changes to key dates, and also variations. Then the questions of if there's an issue with the program, we call this the accepted program. And the program should show the fixed starting date, access date, key dates, and all these things, the important aspects of the contract. Then upon submissions, the project managers are given 2 weeks to notify acceptance. Well, if he fails to do so, in the NEC 4 is deemed to be accepted. So there's this deeming clause here. And in the event the compensation requires a variation, these are the applications that needs to be undertaken. And of course, there is an assessment involved. And for all intent purpose, the core value of NEC is actually on this mutual trust and cooperation. Okay. Then if there is a dispute, unfortunately, of course, they will have to fall under dispute clauses. Then the only problem may be there are parties who change that dispute clauses in the poorly drafted clause act. So this whole thing will derail the true intention of the NEC. Of course, the NEC 3 provide only 2 options, and the NEC 4 provide more. Okay, whereby you have to have a senior representative to actually come in to mediate over the matter before you can actually bring it to arbitration and whatnot. Okay, so this is a very nice things to do. Of course, the NEC 3 will have this dispute avoidance board that is always ready when there's an issue arises. Okay, so now what does the law hold after talking through all these things? The journey when we deal with variation is that the contractors are usually not bound to execute work beyond its contractual scope. So what the contracts actually do is to provide an option that allow the employer to give variation, but then they will be then compensated by maybe a loss of recovery and so on and so forth. Then, of course, there is some issue with the substantial changes. So the question is what being substantial and non-substantial will have to be addressed by the clauses in the form. And of course, it has to be legal in nature because the form cannot provide a clause that undertake illegality into its object. Okay, I think I'm able to conclude my webinar here for 1 hour. I can be contacted from this webpage and also my Facebook account and my LinkedIn and also my email. So you can follow me, please follow me through my social media and let's get together. All right, thank you very much. Matt, I hand this back to you.
David, that was amazing. It's almost exactly bang on 1 hour. You've got this down to a routine now, so thank you very much. So thorough. Now, it does give us that opportunity a little bit to ask the audience just to say a few comments for David. That would be really appreciated. But also, perhaps if you have got a couple of questions, we could put a couple to David before he leaves, if you don't mind, David. If we have any questions. I mean, your presentation is very thorough. So let's have a little look. Oh, somebody joined a little bit late. Thought it was UK time, so not to worry, but we do have a recording for you, so we will send a recording. Zul's commented NEC equals gentleman agreement equals gentleman involved. Okay, question mark, interesting. And Biplak's just confirmed excellent presence. He comes to a lot of our CPD, so that's a good sign, David. Somebody said it's great, very informative presentation. Thank you very much for this. And yeah, just to clarify, we can't provide a pack from David. If you need more information or you want to get in touch with him, then use the contact details. But what we are doing is sending the recording out tomorrow for everyone. So you will get the recording once it's come through and uploaded with us. But we don't send the physical pack. Otherwise, it's sort of you know, it's intended to get in touch with David if you need further help. Brilliant presentation, very informative. This could go on all night, David. It's been a really good webinar. Doesn't appear to have too many questions other than the housekeeping. So thank you very much for your time tonight. What is it now? It's about 7 o'clock, is it? 6?
It's past 6 o'clock in Malaysia. Yes.
So go and enjoy some food. And for everyone who's joined us today, thank you very much for your support. And please, I encourage you to go and follow David if you want some more of his absolute expertise on his LinkedIn, his emails there as well. So just feel free to get in touch. And once again, thank you, David, for taking time out to talk to CIArb and its members and its colleagues.
Thank you very much, Matt, and also to everybody from CIArb. It's nice to have a webinar session with you guys. I'm looking forward for more sessions.
Yeah, it's our pleasure. You take care. Thank you, David. Thanks, everyone.
Thank you.
Bid you farewell.